All persons having business before the court shall all hear give attention to you will be heard. And God save the United States of America, the state of Florida, and the Commonwealth of Florida.
Thank you. Good morning. Welcome to an oral argument session of the 6th District Court of Appeal. My name is Dan Traver. I'll be presiding today. I want to introduce you to the rest of the panel. To my right, your left is the Honorable Jared Smith. To my left, your right is the Honorable Joshua Mize. We have two cases on the docket this morning. Before I call the cases, I would just advise that we are being streamed live on YouTube and that if you haven't already silenced your cell phones, I would be really grateful if you did. The first case today is case number 23-1658. Gentlemen, is the G silent or not? Silent. So William P. Battaglia individually and as co-trustee versus Robert E. Battaglia individually and as co-trustee. Before I recognize you, Mr. Brownlee, let me ask you guys both. There is in the docket a suggestion of bankruptcy and of automatic stay. There was a motion and an order which I presume lifted the automatic stay as it related to this case. It just wasn't in our appellate record. So I wanted to ask before we got started, are we violating a stay? Sure. Mr. Brownlee? No, we are not. Okay. All right. So you, are you making the argument this morning? How much rebuttal time would you like? 7? Sure. Whenever you're ready.
May it please the court. Mike Brownlee here on behalf of Bill Battaglia. Governors, this one's a bear. There's a lot going on factually and legally. I don't envy you having to weed through all this information. I think for purposes of today, the best place to start from our perspective is with what we think is the lowest hanging fruit, which is the damages issue. For many reasons, Your Honors, the trial court's damages ruling cannot be sustained. First, Bill did not commit a breach of his trustee duties. And under section 736.1003, that's dispositive on the damages issue. Because, and I'm quoting from the statute, absent a breach of trust, the trustee is not liable to a beneficiary for a loss or depreciation in the value of the trust property. So no breach, no damages. In addition, section 736.10021A, it's a mouthful. Damages are only awardable to restore the value of the trust property. Here, there was nothing lost by the trust. There was nothing the trust was entitled to. There was no depreciation. In fact, the only evidence as to the value of the trust, which is the stock shares in BFCIC.
Is that a full reading of that statute? Because it talks about restoring the value of the trust property and trust distributions to what they would have been.
Correct.
Okay.
Yeah.
So you just mentioned the first half. How do we address the second half? Are you reading it as synonymous?
I believe so. Yeah. I think the idea is restoration, bringing it back to, lost profits. It's what making the trust whole, I think is the way I think of it.
We've got at least some testimony in the record that there was an established way of doing things until 2018, which is when you had a property that was sold. That money would flow into BFCIC through whatever channels it came through, whatever single asset real estate entity had made the sale. And then you'd have that go to the trust for distribution.
Correct.
So there's an established way of doing things. So is there an argument to be made under that particular statute that the quote trust distributions to what they would have been would have encompassed that Trilago sale?
No, because there's no automatic right for the trust to receive that dividend, right? I mean, the company has to declare a dividend. The board declares a dividend, and only then would the trust be entitled to it. And that's 100% a corporate decision.
In your motion for rehearing that was filed below, you talk about the concept of, well, let me find your language. You talk about the concept of moving it from account 1 to account 2 for a reason that this is 5938 on the record. By analogy, it's as simple as having the funds in account 1 of the trust rather than account 2 of the trust. Assuming arguendo it's maladministration to have not moved the money to account 2, such an action in and of itself does not reduce the value of the trust. And in this example, accounts 1 and 2 were assets of the trust. So I understand that argument to mean that if you're dealing with account 1 and account 2, The argument is there's an inappropriate amount of damages here because your client is going to be entitled to 1/2 of whatever's distributed from BFCIC to the trust.
Right.
And I don't know that that's a crazy argument. However, it seems to undercut the argument that you just made, which is that these are separate corporations with separate corporate indicia.
I can't speak to how it was phrased in the motion for rehearing. I suspect that was for simplicity's sake. I mean, it's not account one and account two of the trust. It's a corporate account. And then you've got the trust account. I mean, those are 100%, and the record bears out that those are very separate accounts held by very separate entities.
Mr. Brenly, how do you read the final judgment? When I look at the final judgment, it says that, Mr. Vitalia shall pay individually the, $2.2 million. While at the same time, the money may still come up through the entities for distribution. I think I saw something in the record that indicates it actually has since then. So do you read this judgment as essentially permitting that distribution to come up through the entities and for them to collect against your client?
100%. I mean, it's at least the potential for a double, but it's certainly there. I think it's outside the record where that money has gone. My understanding from the record is that it's in those corporate coffers still, but absolutely. I mean,
Well, the record reflects that it's been distributed with rights on appeal. So there's a satisfaction.
correct. Sorry.
Yeah.
That's correct.
So that is part of the record.
Right. Okay.
Right. So if the money has come up through the entities and has now been distributed to the trust, your position is there's still that has not satisfied the judgment, that the judgment imposed separate independent liability on your client that needs to be reversed.
Yes. 100%. I think that's the only way to read the judgment.
Yeah, I guess we'll just ask your colleague what the defensible argument is, if that's so, whether he's going to adopt that or not, because it doesn't seem that you look at that statute, that extra half of the $2 million, the big chunk of the damages, there's not a situation where your client still isn't a trustee.
Correct.
Okay.
And again, I know that I'm concerned about the account one, account two verbiage, because to the extent the court's thinking about it that way, I think we have to be careful. It was
your client's position.
Understood, but I don't think that's reflective of the position they took out throughout the proceedings. I think that's the way he phrased it in motion for rehearing.
Yeah, and I mean, for what it's worth, it's a phenomenally detailed motion for rehearing. It's 26 pages long, so it doesn't leave anything on the table.
Right.
Okay.
I think the next, and then removal also, for a lot of similar reasons, removal was not appropriate.
Let me just ask about
Please.
quickly the remaining 2 items of damages. You've got the interest on the Joe Frayne advance, and then you've got the Nelson Mullins.
Correct.
There is some contention, I can't recall whether it's in the motion for rehearing or it's in your briefing, that suggests that the Nelson Mullins legal fee advance had to do with a BFCIC matter. I didn't understand that to be true. Okay. I understood it to have to do with the Luma litigation. Correct. Is there some place that you could point me to in the record that suggests that it was a BFCIC matter?
I need to get back to you on that, but
okay, sure.
I don't know the location, but I know for sure that the record reflects that BFCIC was the parent company basically of the subsidiary that was at issue and was a landlord in the Luma litigation.
So I guess that's the argument, because again, it seems like if you're going to argue on one hand that we're dealing with individual corporate formalities between and among corporations and trusts, that the same thing has to hold true, that if it's the Luma issue and it has to do with a single asset entity that is not BFCIC, I don't know that you can get the benefit of both sides of those arguments.
Understood. And again, I don't think that's too fleshed out in the record. I don't know if the management agreement permitted that kind of use of for legal fund. I mean, I don't know.
Okay.
But again, those are corporate decisions. The only party in this case is the trust, right? There's no BFCIC, not a party. BPL, not a party. None of these entities are parties here. And those are corporate decisions. How legal fees are spent. I mean, those are corporate decisions that shouldn't have been an issue ever for damages or really anything else. And pursuant to the trial court's own pretrial rulings, that's what those the sort of the state of affairs going into trial, which makes the result very hard to explain.
Yeah, I didn't see many, because I think it was just analogous to corporate law, right? If the owner of these entities wasn't a trust, if it was a parent company, if a subsidiary has some kind of lawsuit and it's damaged and it goes after somebody, the parent company can't sue. I mean, if Coca-Cola has a subsidiary that does bottling and it has a breach of contract or a business tort, Coca-Cola can't sue. The company actually injured has to sue. I didn't see kind of a detailed of the kind of, I mean, I saw the assertion, I saw the argument. I didn't see a lot of precedent kind of detailing, you know, as a matter of corporate law, why that is and examples of parent companies not being able to collect. Is there any reason that the law in that area didn't graft over into the trust context when a trust is the parent company? It seems to me that would operate the same way, but I didn't see anything in the brief where it says, hey, here's how this works in corporate law and how we all expect. And, you know, here's why there's no reason it should be different in the trust context, or nothing about the trust code makes that any different here.
I think I understand your question. The Parker versus Schulman case out of the fourth DCA, that's where I would direct you for the best. That at least has a description of, you know, it's a similar situation. Trust owns stock in the company, and the challenge, the company is not a party, and the challenge was to the corporate compensation of the trustee. And the fourth DCA says, no, you can't, unless the corporation sued and you bring a derivative action, and you can, you know, do all the other things you have to do to comply with corporate law. You can't, it's not a trust issue. That's as close as I can get.
You wanted to talk about removal. You got 3.5 minutes before your rebuttal time, so please, however you see
I think
fit.
I'll reserve, actually, unless the court has any more questions.
Sure.
So I'll just throw out one question, Mr. Brownlee. So that with the 2.049 million for the failure to distribute the trust proceeds, the sale proceeds. My understanding is, and this has already been discussed, it's been moved into an account essentially ready to be distributed at this point in time, correct? So let's say it gets distributed. Isn't that a post-judgment set off for your client? So isn't that issue presently moot?
I think not, because I mean, this is the problem with the separation of the corporate entity and the trust. I mean, well, I guess I don't understand the question.
Well, I mean,
how do you-
once that money gets into the hands of the beneficiaries, isn't your client then going to say, Judge, we get a set off for, you know, for this judgment that's currently against us in the amount of?
In a perfect world, but now we've got a lot of different, you know, the damages award is against my client personally. Right, so I don't know that he'd be able to get a set off. If that's a deduction from the corporate coffers.
I think the problem is judgment says he's personally liable.
Right,
And maybe there's a 1.540 inequitable enforcement sort of defense.
maybe you'd love to not be there, though.
No, I get it. I get it.
Yeah.
Okay.
Okay.
Thanks,
you.
Mr. Brownlee.
Thanks,
Yes, sir. Good morning.
Morning. May it please the board. Bill Spivey and Courtney Keller of Greenberg Traurig on behalf of Robert Battaglia, who I will try to refer to as Bob this morning for purposes of avoiding potential confusion. The trial court got this right.
Counsel, can you start with the first question we asked about the judgment?
Sure.
So if those distributions were to happen, right, so the money from BPL and BFCIC comes up to the trust, is your position that Bill Battaglia still owes the $2 million under the judgment?
We don't care where the money comes from. I think Judge Smith hit it on the head. This is a matter of collection and a matter of enforcement.
I guess what I'm saying, but do you view that as the judgment being satisfied? So if that just, you know, your client's the trustee now, or you know, Bill's the trust, or Bob is the trustee now. If Bob distributes that money, if it comes up from BFCIC and BPL to the trust, and Bob distributes it to the trustees, which is half to him and half to Bill, has the judgment, at least the distributions part, has that $2.049 million, has that been satisfied?
When that happens, it will be satisfied.
Okay.
Yes, sir.
Okay. So your position is that whatever individual liability there is not duplicative of the distributions actually happening. And if they happened, your client cannot collect from him individually that $2.049 million.
We're not seeking a double recovery, to answer your question. If we get the money through the chain of entities, we'll be satisfied.
Okay. I guess I want a little more of a definitive answer. If that distribution comes up,
Yes,
do you concede your client cannot collect on any additional money for that 2.049 for the distributions part, for the BFCIC and the BPL distributions? If that money comes up and is distributed to the trust and then distributed to the beneficiaries, do you concede your client cannot then collect any other portion of that money from Bill Battaglia individually?
correct. Yes, sir. I think the potential misunderstanding here arises from what really underpinned the court's determination is that all of these funds were opportunities. And if you look at 736-0802 subpart 4, the legislature speaks of opportunities. Bill Battaglia had an obligation to maximize every opportunity that was available to the trust. And he put himself in a hopeless conflict of interest that required him to either resign or to get guidance from the court. And it's ironic that he didn't do any of that. Instead, he set out on a unilateral course of tyranny that, frankly, I think is unprecedented in the jurisprudence. In all the cases that we looked at, I can't find anything remotely close to the kind of conduct that Bill Battaglia engaged in. He was openly hostile to his co-trustee. He was openly hostile to all beneficiaries. He excluded Bob Battaglia from every decision that was made. He instructed other people not to interface with Bob Battaglia, not to give him the information. You'll recall that Bill Battaglia testified that he viewed Bob as an obstruction and the biggest waste of my time. That's not fiduciary behavior. That's not how you interface with your co-fiduciary.
Can I keep you on the damages, counsel? So if we go on to the next category, the legal fees and the interest thereon, I'm trying to think of any other context where a company suffers damages, right? Those entities suffer damages as a result of their, Bill Battaglia, at least according to the judgment, as a result of him spending money he shouldn't have from the entities. And so I'm trying to think of any other context where a company suffers damages, and rather than that company taking legal action, the shareholder of the company's parent entity, right? I know it's not a business entity, but it's an entity, it's a trust. The parent entity that owns the subsidiary that was actually damaged can sue for damages directly on behalf of the parent entity based on damages actually suffered by the subsidiary. Is there any other place in corporate law where that's a thing?
Respectfully, I don't know that that analogy applies to this circumstance because this is a trust. And Bill Battaglia was obligated under Florida law to act solely in the best interest of the beneficiaries. This isn't a corporate context where there are parent entities and subsidiary entities. And I submit that the fiduciary obligation imposed on Bill Battaglia as a matter of law exposed.
I think what you just said there is not correct. I mean, a trust is an entity, right?
Sure.
And a trust can own a subsidiary, trust can own an LLC, right?
It could, yes.
If it owns an LLC, then it is the parent entity of that LLC, correct?
Yes, sir.
Okay, so the statement that this is not a context of parent entities, that's just obviously false, right? That was incorrect to say that.
If I misspoke, I didn't mean to, but I think there's a distinction between being a trustee and being a corporate entity.
Well, but that speaks to whether, I guess, is like whether or not he should have done it. I'm talking about where the damages flow to, right? So you have an entity that suffers damages and it has a parent entity. Normally in the corporate law context, you would expect the entity actually damaged to have to sue to recover that money. A parent entity cannot just sue directly to recover damages suffered by its subsidiary. So I think that's clearly how it works in corporate law. That's what happened here. So I guess I need you to tell me, why is it different in the trust context? What about there being a trust as the parent entity means that it can recover damages suffered by a subsidiary? Is that always the case with trust? Do they have some kind of different, are they different in corporate law somehow where they get to sue for subsidiaries damages where other parent entities do not? Give me the basis for that distinction.
Look at 736.0802 subpart 6 that talks about when a trustee is voting shares or acting in a corporate capacity on behalf of some related entity. He's obligated to always look out for the best interest of the trust. And I think that is a critical distinction here that gets you out of the hypothetical that Your Honor described. Is Bill Battaglia's breaches of fiduciary duty exposed him to liability for every opportunity that was available to the trust in which he failed to pursue. He was on a hopeless conflict of interest that he could not just unilaterally resolve as he saw fit. But
So
that's,
when you talk about, Mr. Spivey, you talk about 736-0802. That's a liability, what a trust or what a trustee can and can't do. If I'm looking at the damages statute, which is the 736-1002 sub 1, which talks about how we categorize damages when those things occur, which I think is a separate issue. It talks about the amount required to restore the value of the trust property and trust distributions to what they would have been.
would have been.
Do you view those as two separate categories of damage, or like Mr. Brownlee, do you view them as interchangeable and the same?
No, I view them differently. And I think the would have been is consistent with the opportunity verbiage in 0802.
Okay, so if you've got on the first hand, you've got restore the value of the trust property. Are you suggesting that the Nelson Mullins loan and the Joe Frayne interest were trust property?
Yes,
Help me understand that.
they were opportunities, again, Your Honor.
What's an opportunity like that? I mean, the allegation is he took money he shouldn't have. I get what like a business opportunity is. Taking money out of a bank account you're not supposed to. I'm confused by the use of the term opportunity to refer to that. I can see misappropriation of funds. I don't see why you keep using the word opportunity.
I'm taking it from the statute, Your Honor. That's where I'm getting that. And there's some case law that speaks of a trustee usurping opportunities.
But how does this fall into that category? It wasn't a business opportunity where he's like, do I want to pursue this or I want to let the trust pursue it? He took the judgment found he took money out of a bank account he wasn't supposed to. It was put it to somewhere he shouldn't have. It was a bank account of the subsidiary. Why does that fit into the opportunity bucket?
That money should have flowed to the trust. It was
Can
an
you help me
opportunity.
can you help me understand that? So I understand, there was record evidence about the common way of doing things,
Mhm.
before this failed succession in 2017, 2018. Is there anything in the record that suggests that that particular money, that $100,000 or that $3,000 would have in the normal course of business flowed to the trust, either generally or specifically?
It should have, but for
Yeah, I'm just
Bill
asking where.
Battalia's breaches.
Well, I'm just asking where in the record that happened, because I understood the normal way of doing things with with BFCIC and the subsidiaries underneath it, was that they had to run a business. So there's operating costs, there might be carry costs, there might be property taxes, all of those sorts of things. But then when one of those LLCs was sold, that's when things would distribute up. How do I view the Nelson Mullins and the Joe Frayne? Do I view them in the bucket of being a sale that goes up, or do I view them as being misplaced operating costs? Or am I making an incorrect distinction?
Again, I think it's cash that would and should have been available for distribution to the income beneficiaries, which was Bill Battalia's obligation as the,
What's the CSE that it actually would have been distributed?
I'm sorry?
What's the competent substantial evidence that it actually would have been distributed? In other words, what if they had that extra money, they would have given the employees a little extra Christmas bonus that year. Like they wouldn't have distributed up. They would have used business judgment. Since they had the money, they would have used business judgment and decided, yeah, it's in our interest to give employees a bonus this year. That's a competitive labor market. Just because they had it doesn't mean it would have been distributed up.
Respectfully, I don't think that Bill Battaglia is entitled to that indulgence, if you will, because he did all of this secretly, unilaterally, without any consultation whatsoever with his co-trustee.
That goes to liability. The damages that restore the distributions to the trust that would have been. So the fact that you think he's like really obviously guilty, that has nothing to do with whether or not these monies would have been distributed up, counsel. That seems to me to be a different issue.
I think the court had sufficient evidence before it to find that those monies would have and should have flowed.
So my question was, what is that evidence?
I think it was a testimony of Bill Battaglia.
He testified if that money had not, if they had had the interest on those monies,
No,
he would have distributed it up, because I
Bill
didn't see
Battaglia
that.
did not testify about interest on anything.
Okay.
But I think his testimony about the established pattern, the established course, I think that was a sufficient predicate for the trial court to find that those funds would have and should have been there for distribution to the beneficiaries.
Yeah, and I'll just ask one more time, because I'm a little bit hung up on the same idea, perhaps as my colleague is, which is where in the record does it specifically talk about anything other than property sales being distributed?
I don't know that it does, Your Honor.
Okay.
I can't point you.
Is that a challenge for you then?
Sure.
When we're talking about money that was sent off to pay a Nelson Mullins retainer for something that might not have been BFCIC business?
I don't think so. Certainly with the $3,000 accrual, that is in a different category. But there are $350,000 that Bill Battaglia diverted from BFCIC for his own personal benefit. Okay. I think there's absolute liability for that. And I think there's certainly a expectation that that magnitude of money would have flowed to the beneficiaries of the trust.
So basically, if I understand you correctly, you're saying that the 110, the Nelson Mullins retainer, is effectively compensation for him otherwise taking the 350 out.
Yes.
Okay.
Yes, sir.
Also, in other cases, if you have a subsidiary and the CEO of that subsidiary, embezzles money from the subsidiary, isn't it the subsidiary that has to go after him rather than the subsidiary's parent company? I mean, if you had the Coca-Cola distributor, right, that's a wholly owned distributor of Coca-Cola, and it's got a CEO, and Coca-Cola finds out that that CEO of the distribution subsidiary has been stealing money or took money for his own funds, they would go after him on behalf of the subsidiary. The subsidiary would say, return that money. The parent company couldn't itself directly go after him, could it?
I think the distinction here, Your Honor, is that Bill Battaglia is part of that parent entity.
So as a matter of corporate law, okay, say he is also the CEO of the parent entity. Say the person is CEO with the parent and the subsidiary, which can happen, and he takes money out of a subsidiary's bank account. Does the fact that he was involved with the parent company as a matter of corporate law mean the parent company can sue him for damages suffered by the subsidiary? I mean, you're a corporate lawyer, Mr. Spivey. Is that how it works?
I think it does in this context, Judge, because we have this trust statute that does not exist in the corporate world.
All right, so give me the language of the trust statute, which you would say this changes how basic corporate law works.
It's the two statutes that I referenced, 0.1002 and 06.
What part of that language changes the basic structure of corporate law if a trust is involved? Read me the words. Because I don't see anything in there that says trusts operate differently when they're a parent entity than every other type of parent entity in all of corporate law.
Trust law gives us the opportunity to pursue opportunity losses. And Bill Battaglia created enormous opportunity losses for the trust.
Can I ask your question in a slightly different way?
Sure.
If we reverse on the Nelson Mullins retainer, does BFCIC have an action against Bill individually for usurpation of corporate opportunity?
It probably could.
Okay.
I mean, Bill Battaglia can be sued any number of ways. I mean, against this pattern of misconduct, there are any number of people who could sue him. He certainly engaged in corporate mismanagement. He engaged in trust abuses. He engaged in.
If the subsidiary can sue, that really seems to cut really strongly against your argument, because that kind of speaks to the fact that it's the subsidiary's lawsuit. What you told me, it's different in this case because as a trustee, he had a duty to the trust. Well, the CEO of a parent company corporation would have a fiduciary duty to the shareholders of the parent corporation, wouldn't it?
The fact that one party could sue another doesn't mean that that's the whole universe of who else could sue.
Okay, but you said it was different because, well, the trustee, this works different than all other areas of corporate law because there's this trust statute that imposed a fiduciary duty on him as the trustee of the trust. Well, the CEO of a parent company that was an LLC, it would have a fiduciary duty to its shareholders, right? I mean, don't corporate officers always have a fiduciary duty to their shareholders?
Of course,
Okay, so why is that a distinction between a trust and another entity that's a parent company?
because the trust statute speaks of opportunities. And I
No, but corporations speak of, the corporate law speaks of opportunities. Corporate officers cannot usurp business opportunities from the corporation for which they work. I mean, their corporate officers can be sued if they do that. So the fact that there is an opportunity to an obligation to account for opportunities to the trust, that doesn't make it unlike other entities. That makes it exactly like other entities, right? Does not the CEO of a corporation have a duty not to usurp corporate opportunities from the corporation? Isn't that basic corporate law?
that is true.
Okay, so why is that a distinction between another type of entity and a trust rather than evidence that they work the exact same way? The distinction you gave me is not a distinction.
Again, I don't mean to be argumentative with your honor, but I think the statutory scheme of 1002 and 0806 exposes Bill Battaglia to liability for all these things.
When I asked you why, you said because of this opportunities language.
Yes,
Okay. So that also exists in other types of entities. So why is that still a good argument?
it doesn't exist in statutory framework. I mean, it was a common law, right? But I don't think the statute, chapter 607, the corporate statute, I don't think it has this opportunity language that's in 0806. I think
I guess one last question. Would this mean that if we were to write an opinion of affirming those damages, right, and saying that a trust can go after a subsidiary's damages, provided the damages are caused to the subsidiary by a trustee of the trust, that'd be pretty set in a statewide rule now, right? That whenever a trust owns a subsidiary, if the trustee damages the subsidiary, the trust can sue the trustee directly. That'd be the rule across the state now.
if you fashioned it that way, it would.
Is there any way to write an opinion affirming that doesn't fashion it that way?
I think you could.
What would that be?
I think the Diamond Trust case we cited in our briefs. Trustee serving the corporate opportunity. And in that case. I have. Just remaining. Bill Battaglia is not entitled to any favors here. Engaged in all acts and for deficient and vulnerable in any number of ways. There's nothing about his.
Are any of the
conduct-
legal standards for damages here involve benefit of the doubt based on somebody being a bad guy?
I'm sorry.
Do any of the legal standards for damages we have to apply here involve saying somebody doesn't get the benefit of the doubt because they're a bad guy?
Damages are damages, and they
Okay.
have nothing to do with.
Okay, so
whether-
why is it relevant to say, well, listen, keep in mind you decide this, he's a bad guy? That doesn't seem like a legal argument to me.
This is a court of equity. And I think the trial court tried to do the right thing, and I think it did do the right thing. It found Bill Battaglia to be a very unsavory fiduciary. The findings of fact are unrebutted. Most of the case came from Bill Battaglia's own mouth. And most of the case came from Bill Battaglia's own unilateral acts that happened after the litigation was filed. When the litigation was pending, Bill Battaglia was out doing all these unilateral outrageous things. And it was very displeasing to the trial court. And I would request the court to affirm this in all respects.
Thank you, counsel.
Please, court.
Yes.
Your Honor's awful, horrific. This is in large part why we got here. That opening of Mr. Spivey's statement.
Mr. Brownlee, I don't want to interrupt, but
Please.
I have to. We only have so much time. So you just heard obviously counsel for Mr. Battaglia say that his particular stipulation, I'm going to ask if you would join with it. Do you join with Bob Battaglia's counsel's stipulation that if the 2.049 million distribution goes forward, that would satisfy the $2.049 million individual judgment against your client? Do you join that stipulation that he just made before us?
I don't, as I sit here now, I don't know.
Is there a reason that you wouldn't? I mean, he
No, I mean,
basically said it's a 50% haircut.
I suppose so, but it sure seems like a roundabout way to go about it. I mean,
Hold on, I guess it goes to how do you read the judgment, right? I mean, what you're putting your brief to us and argued was this judgment allows for double recovery, right?
Right.
And that's one of the main arguments, and obviously that would be a good argument to allow for double recovery. I think what we have is a matter of interpreting the judgment, a stipulation from the other side. We don't read it that way. We don't believe we have a right to enforce it. I think there was a pretty definitive concession that if that money is distributed up, that portion of the judgment is satisfied, and we cannot go after Bill Battaglia.
well, I'll take it.
If that was a correct reading.
I think
of-
that's what.
I guess what I'm saying
I'll
is,
take it. And I don't mean to
assume,
look-
I'm not saying you agree with that reading of the judgment.
Right.
But if that were the correct reading of the judgment, as a matter of just interpreting it, that would eliminate the double recovery problem, right?
I suppose that's right. Yes.
He would have had a very different experience up here if he'd have said he could still get an extra $1 million.
Yeah, I suppose so.
So with him conceding that, and you agreeing to that concession, does that then at this point moot the appeal regarding the $2.049 million individual judgment against Mr. Bill Battaglia?
From a damages perspective, I suppose, I mean, maybe, but I suppose so, but the problem.
Nobody's asking you to moot any other aspect of your appeal. This was a
Okay.
200-page collective briefing. There were lots of things that were argued.
Understood,
Yeah.
then yes, I suppose it does. Your Honor, the beginning of Mr. Spivey's presentation about this is unprecedented in the trust cases, it is the exact opposite. Okay, if you read any of the trust cases for removal, damages imposed against an individual trustee, they are actually horrific things. They're stealing. There's violations of the duty of loyalty. My client tripled the value of this. I mean, tripled a fortune.
Because
over
I
his-
think you heard my question, your opposing counsel. I don't think any of the legal standards we have to apply based on for the damages here go to level of badness or lack of level of badness.
Correct, but it does for removal, right? I mean, and just in a general sense, I mean, this is a hard.
Let me ask you this on
But-
removal. You have this lack of cooperation prong, as the basis for removal, which seems to me to be pretty broad, right? Was a trial judge looking at the lack of cooperation? Was one of the things a trial judge could take into account the family dynamics of this trust? In other words, could he look at two sides and say, I've got one person and then I've got, every other person in the family, and there's been a complete breakdown. If it's like 14 or 15 against one or however many on the other side, I can take that to mean he's the problem and there's a lack of cooperation. Like, isn't there a lot of broad reasons you could look at that as a lack of cooperation, including nobody in his family will speak to him? That was in the record on either side. Like, isn't that on its own enough to show lack of cooperation, at least at a CSE level? I mean, we're not here as fact finders, we're here as CSE reviewers, right?
Understood. If the statute said, just lack of cooperation and stop there, maybe so, but it says a lack of cooperation that substantially impairs the administration of the trust.
Okay,
The
so
trust in this
every
case doesn't-
single other person involved in the trust at every single level, in terms of the beneficiaries and the trustee, won't speak to him and hasn't spoken to him for years. You don't think that, I'm not saying that it means who's right? Even, that doesn't even speak to who's right in that dispute, right? It just speaks to, for whatever reason, every single other person who has an interest in this trust will not speak to him and he will not speak to them. And just as a matter of administration, it's a lot easier when you have 14 or 15 people with an interest in one.
Yeah.
It's a lot easier to get rid of the one, right? Could a trial court now look at that and say, just that dynamic, however you got there and whoever's fault it was, impedes his ability to operate the trust?
Maybe, but not in this case, because you have to substantially impair the administration of the trust. The trust in this case doesn't do very much. It collects, if a corporate distribution is made, dividend is declared, the trust is distributed. I mean,
What about his demeanor in court? Okay, so the trial judge is entitled to evaluate, right, the witnesses and determine, what do I think about this person, right?
Sure.
Okay, and he made some harsh findings to your client, right? Can that not be CSE of, all right, is he not allowed to look at this person and say, I've personally watched him testify. I've seen him interacting in the courtroom with his family members. I don't think he can cooperate with the rest of the family in a way that, is functional and allows the trust to operate
If
well.
there was evidence that was impairing the administration of the trust, I would say yes, but there's not in this case. I mean, the most of what the trial judge was talking about were the remainder beneficiaries who have extremely limited rights under the trust agreement. I mean, they
They have knowledge rights, and it's hard to exert those knowledge rights if they can't speak.
but you can't just not speak to someone and then say, we're not getting along. I mean,
He didn't, I think the evidence showed neither one wants to speak to each other, so your client doesn't want to speak to them either, right? Well, that's a two-way thing.
right. I would just say there's no evidence that the administration of the
Yeah.
trust was ever impaired.
The other thing I didn't
Trust
get on
fund.
these disclosures, there were 7 years of lack of disclosures, and the argument in your brief basically was, well, we just all, Bob and I together decided not to do the disclosures for 7 years. And to me, that really doesn't mean there wasn't a breach. It just means it sounds like Bob agreed to the breach.
I agree.
Right. Okay, but that doesn't mean everybody else agreed to the breach, and it doesn't establish a lack of a breach, and nobody's suing to remove Bob.
Yeah.
Right? So I didn't see anything in your brief that would establish that wasn't an obvious and clear breach of the trust code.
I would agree that it was. I would agree
Okay.
It was, but it was cured. I mean,
Okay, but does the removal statute say breaches that are later cured cannot be a basis for
no,
removal?
they say it has to be a serious breach. when it
But
comes to
but
removal.
serious and cured are two different things, aren't they?
Right, I would argue that the failure to account was not a serious breach. I mean,
Okay.
there's not much accounting to be done.
Okay, but
you
the
look at
fact that
the
it was,
accountings, they're
but the
not.
fact that it was cured certainly has nothing to do with whether it was serious to begin with, does it?
No, it doesn't.
Can I ask you just in the legal, because you're running out of time, the interest and the legal fees, all right? Can you tell us why your opposing counsel is wrong that that operates differently when the parent company is a trust than it would if a parent company was some type of corporate entity?
Basic corporate law, I mean, everything that you were suggesting, I mean, that's not how it works. Those are corporate funds. It
Can you
was
respond to this argument that that falls into this opportunity bucket under the statute?
opportunity for what? I mean, the trust had there was no opportunity for the trust just because those funds were sitting in BFCIC's coffers. That's not an opportunity. It's not nothing's an opportunity until there's a dividend declared by BFCIC. To talk about it as an opportunity is, I think, thinking about it in completely the wrong way. There is no opportunity. There is a duty to distribute by the trustees if and when money comes in. That's it. Otherwise, it's a derivative action. And your honor, my client testified at length about all the reasons that 2.4 million wasn't distributed. It would have been a horrible idea from a corporate standpoint to do that. I would encourage the court to read that testimony, and he should be entitled to the business judgment rule. He should be entitled to there should have been derivative suit compliance. I mean, you can't just latch on all of the stuff to trustee law when it's basic corporate law. I see I'm out of time. Thank you, your honor.
Thank you both for your presentation. We'll take the case under advisement. Yeah, we'll take a 5-minute recess. Might be closer to time.